Welcome back. 17-year-old Dillon Siebert was sentenced to 7 years after he and 2 other friends set the wrong house on fire in Green Valley Ranch. Siebert was 14 years old at the time. Police say one of the friends' phones was stolen during a drug deal, and a computer app tracked the phone that led the teens to the wrong house. 9 News legal analyst Whitney Traylor joins us now to talk about this case. Very interesting. Thanks for coming in.
Sure, it is really interesting facts for sure.
So they found these teens through a Google search warrant because they were trying to find where the phone was pinging.
Yes.
Now they're looking into whether that was even constitutional. Talk about that.
Right. So what's happening now is there's going to be a hearing in front of the Supreme Court because the district court has already said that the way that they obtained the search warrant was lawful, and their defense lawyers have filed a motion actually to suppress the evidence that was discovered as a result of that. And so what the real issue is they didn't have, usually you get a search warrant, it's very specific. They want to look in a specific file folder on your computer, or they want to look in a specific room. Here, they did a reverse warrant, and so they essentially got a search warrant for Google, and then were able to track who was looking up this specific address. And it tracked to the boys, and they had looked up this address 3 times in the previous however long. And so the real issue here is, well, if you can do that kind of a search and get a search warrant, then anything that we do online is subjecting us to potential criminal liability because it's, you know, and the defendants called it a digital dragnet. And this is sort of the essence of a fishing expedition. And so what happens is we have a Fourth Amendment right to protection from unlawful search and seizure. And so what they're saying is that this was an unlawful search and seizure because it violated his privacy, and it was just this broad search that searched technically billions of people. But only these boys had searched for this specific address, so they were able to track them down, and that was what led them to the boys, and that was what led to their arrest.
Is this a new thing? Like, would this set a precedence on like where they move forward with stuff like this?
Right. Yes, this is a very new thing. So there was a case, I think, in 2017, but this case in particular, as what they call a reverse search, a reverse Google search, is actually the first time really that the courts are looking at it. So although the case is going on at the trial court level, they're essentially pausing it so they can appeal this issue in front of the Colorado Supreme Court. So there's going to be a hearing on May 4th in front of the Supreme Court who's going to decide, was this constitutional or not? And if they decide, yes, it was constitutional, then the case will go forward.
One of these teens has already been sentenced. What happens if they rule this unconstitutional? What happens with where they've gotten so far in the case?
Right. So the law students will know this. It's called fruit of the poisonous tree. And so they say, look, if the search was not good, meaning you shouldn't have gotten that search warrant, anything that you found as a result of that search can't be used. So that's why a lot of times district attorneys say we can't prosecute because we can't use the gun or we can't use the body that we found. So here, if they were able to suppress the warrant, then the police would have to show, well, we would have discovered them anyway. It's called inevitable discovery. So essentially, if the courts rule in favor of the defendants, then the prosecution may not be able to go forward. They may not have enough evidence because all of this evidence was found as a result of the search warrant.
This may not be the right legal lingo, but I think you'll get where I'm going here. So right now everything is paused in this, right? I mean, they've moved forward with the one case, but now everything is paused. You said this next thing is on May 4th. Does that interfere with like the right to due process in a speedy manner, the fact that so much time is passing in between?
Right, so it's a right to a speedy trial. That's exactly right. But no, there have been a number of hearings and motions, and so they're all in agreement because, and that's actually why they set the trial to continue on May 26th, was because they wanted to get a decision from the Supreme Court on May 4th. So things, even though it seems like it's taking a long time, it's still moving forward in its proper course.
Well, we'll see what happens. I'm sure we're going to bring you in after May 4th, whatever they decide.
Yes, I'm going to try and sit in on that hearing. That would be interesting to hear those arguments on May 4th.
Yeah, Whitney, as always, thanks for coming in.
Sure thing.